Lawyers, what was the worst golden child case in your practice? Story 1. I have had several, but the best was a custody/divorce about 5 years ago. This guy was a super smart engineer, but he fell for a woman who was just white trash. He married her, and at the time of the divorce they had 2 kids aged 6 and 4. One day she told him she wanted a divorce and wanted him to move out. It was a huge house in a gated community, so I advised him to move to another part of the house so he could be near his kids. I also told him that the reason she wanted him out of the house was so that she could have the man she was cheating on him with move in. He did not believe she was cheating, so I told him to go to the gate and check the logs. Sure enough, my client left every morning at 6:30 a.m. for work, and around 7:30 a.m. 3 to 5 times a week, another man would check in at the gate and say he was headed to my client's house. I dug into the name, and it was my client's wife's ex-boyfriend, who was fresh off an 8-year stint in prison for sexual assault and attempted murder. Part of his parole was having to register as a sex offender. My client confronted his wife and recorded her response, one-party consent state. She basically admitted to cheating, admitted to her lover being a sex offender, then told my client she wanted to move her lover in, and if my client did not move out, she would make their children's lives miserable, and make sure they know it is because daddy is being selfish. She lawyered up after that, and we played the tape for her attorney in the first conference. He made some noise about consent and it not sounding like her, but he knew her allowing a registered sex offender around her kids was damning. In the end, he got the house, full custody, and the bank accounts. She got 1 car, her clothes and jewelry, which were very valuable, some of the household items, and $25,000 cash. She literally moved from a palatial home in a gated neighborhood in the nicest part of town into a trailer in an unincorporated part of the county. Don't marry trash. Story 2. A law clerk working in family law represented a stay-at-home dad seeking divorce and custody of 6 children, portraying a wholesome family life on a farm. The client claimed his wife had left the children unsupervised at a public event, including a 2-year-old, to bolster his custody case. However, during a hearing in the judge's chambers, it emerged that the client's desire for divorce was not sudden. He had formed a relationship with another parent outside the marriage while his wife worked overtime. He failed to mention that his wife threatened to call the police after discovering evidence of his actions, not abuse as he claimed. Text messages revealed he knew about the event but did not intervene, hoping it would harm his wife's case. He also tried to manipulate his wife for money, claiming to have pictures of their children's diaries documenting alleged abuse, and spent joint account money on personal matters. The lawyer had to address his demand for spousal support, warning it would end if he remarried, leading to his frustration. This lack of disclosure turned the case into complete chaos in court. Story 3. In a child custody case, grandparents sought conservatorship of a preteen girl from unfit biological parents, with the lawyer asking standard questions about their home and criminal history. The child care plan involved the girl being home alone for a few hours after school. During the hearing, cross-examination revealed the grandparent's son, a person with a criminal record for sexual offenses who lived in a trailer on their property, potentially having access to the child during those hours. The clients explained they did not mention this because the lawyer only asked about people living in the home, not on the property, and they did not see it as relevant. Despite this, they won the case due to the parents' poor conditions, but the lawyer was frustrated by the omission. This case became a firm example of having someone with a serious criminal record living on the property as crucial undisclosed information. Story 4. I normally defend construction defect and personal injury matters, nothing too crazy. Early in my career, we got a case involving a husband and wife who ran a foster home, and one child was alleging the husband had abused them. I was assigned to defend only the wife under their homeowner's insurance policy, being that the allegations against the husband were serious, but the wife had no idea what was going on. Here was this woman, who was also a former foster child, trying to give back and help other foster children in the system, and now she finds out her husband is an alleged abuser. It was heartbreaking, and we just wanted to get her out of the case. Being new, I should also clarify that once a lawyer takes on a case, it's not that easy to just say, actually, I changed my mind. Then we got more documents and learned this wasn't the first child to make allegations. The dad had been engaging in this behavior for years, and she knew it. Maybe she was involved, maybe she just ignored it. Either way, the whole situation turned extremely disturbing, I instantly wanted nothing to do with it. A few weeks later, my boss, the coolest guy ever, comes in and says he gave the case back to the insurance carrier, thank God. That was the only case I've ever felt morally opposed to handling. I don't know what my boss did to get rid of that case, but I'm glad he was equally disturbed. Story 5. I am an attorney, but the case that stuck with me most was one I sat in on during undergrad. I was a criminal justice major and frequently had to watch trials for class assignments. Being in the military at the time, I had to fit these hours in randomly. If we had a light day or I could take a long lunch, I would go to the closest courthouse and check what was available. One day I went down to the federal courthouse in Baltimore and checked the list. One criminal case, nothing else going. I headed upstairs and quietly walked in. Despite that, clearly everyone noticed me, which was odd. Usually no one pays attention to the gallery. At the first break, a guy comes over and asks who I am and why I'm there. He's with the Office of Special Investigations with the Air Force, so I showed him my ID and explained I had to watch criminal trials. He gave me a weird look, but didn't push. As I was sitting there, I slowly realized I should not be here. An Air Force couple had a son and got divorced. She took the son with her to her duty station in Japan and remarried a civilian employee there. The father was deployed, then moved stations, and kept asking when he could see the son. At some point, she stopped responding. A few months later, after the father filed a report with her command requesting communication, he got a call from an OSI agent. The agent asked for his son's full name and DOB and instructed him to contact OSI on her base. The mother had gone to the field, and the 8-year-old son had been bothering the stepfather while he was gaming. The stepfather physically harmed the child with a banister from the stairs. The mother returned 2 days later and found her son unresponsive on the floor. Because the stepfather's last home of record was in Maryland, he was tried in federal court in Baltimore. I sat through the ER doctor who treated the son, who talked about the serious internal injuries, and the coroner who explained how much force would be required to cause such severe bruising. I also sat through the father talking about finding out his son was critically injured. After that day, I always went to misdemeanor court for my hours. Story 6. Many years ago, but this case will stay with me forever. After hours, small rural hospital, understaffed and under-equipped. Pediatric ward, baby very ill with gastroenteritis and hadn't responded to weeks of treatment, was losing weight despite everything. There was no doctor on the pediatric ward that night, or, in fact, in the entire hospital, when the lab phoned the baby's blood work results to the nurse on duty and said the baby would die soon if he didn't receive urgent treatment. The nurse phoned the doctor on telephonic call, who wasn't supposed to go in, having already worked long hours that day, just be available for phone calls, and the doctor gave instructions for a sister to give an ampoule of potassium chloride. She wrote down the instruction. The doctor didn't specify that it be given orally, which was what was meant, but because the doctor specified that a sister must give it, she assumed it should be an injection, as she herself wasn't qualified to give injections, but a nursing sister is. The nurse called the sister from the maternity ward to carry out the instruction, explained the urgency. The sister was very busy in the maternity ward but came to the pediatric ward and gave the injection. The baby died from sudden cardiac arrest. The partners in the firm didn't want to touch the case as they thought it was impossible. But in our law, negligence has a specific definition. I won the case for the nursing sister by arguing that my client was trying her best, with only the instructions and resources at hand, under circumstances where she had been told the patient would die very soon if the treatment wasn't given. She was an amazingly dedicated person, and what happened had completely devastated her. She wanted to quit nursing. I hope she changed her mind after that. Afterward, the one good thing that came out of this tragic event was that I mentioned to a local Rotary Club member that the hospital in question desperately needed some telemedicine equipment, knowing that the club had such a project. And shortly after that, they were able to make a donation of equipment to the hospital. I even coincidentally saw that doctor in passing years afterwards, and the doctor was so grateful for that equipment. This was not in the USA. Story 7. I was only a part of our trial team, meaning I just drafted pleadings but didn't do the stand-up work at trial, but there is one case that really showed me I'll never work for the man again. The case basically involved a little girl with severe disabilities, mind of a baby, no talking, motor skills / strength of a baby, pretty much can't do anything on her own at all, who had been allegedly harmed by her caregiver. The caregiver worked for a state agency, and we were the firm that handled all of this agency's litigation. To make a long story short, no one at this agency knew what they were doing, and the actual caregiver had no training whatsoever in dealing with special needs children. This was in a really remote area, and they hired the caregiver at the last minute, knowing she wasn't qualified. The girl's disabilities were so severe that it would honestly be hard to say whether or not she was actually harmed by the inadequate care. The problematic part was how much money all this cost. The state spent nearly $100,000 modifying its facilities so the girl could get in, out easier and use the restroom more easily. We, because we had to defend the case, hired all these experts on disability law, medicine, neuroscience, psychology/psychiatry, etc. A single expert report and a few hours of testimony can cost $30,000. And this case had at least 4 experts testifying for us. So the state spent a lot of money before the case started trying to help the girl. Then we spent a huge amount defending the case, with at least 6 lawyers involved, including 2 partners. On top of this, the girl's family obviously had to hire lawyers to fight ours, so they spent a lot of money too. Their representation was on a contingency fee, but they were still responsible for other costs, and they were extremely poor, living in a remote area in a substandard house, with neither parent employed. They mostly survived because of government checks that paid them to be their daughter's home health aides. Nonetheless, they incurred significant expenses. We won at trial. It should never have gone to trial, but that's another story. I didn't attend most days of the 2-week trial because I had to work, and I was too junior to be trial counsel in federal court. I did attend to hear closing arguments and the verdict. When I heard the verdict, my first feeling was mild relief. It's important for the firm to win cases like this one. I had also spent a lot of time working on this case, so I was glad that my work had an effect. Story 8. A while back, I represented credit card companies suing for outstanding debts, where we had pretty stringent client guidelines dictating how we handled lawsuits. The bottom line was that we were to be aggressive in court so as to put our client in favorable positions during any settlement negotiations. One defendant was a 40-year-old woman who had maxed out all her credit cards in a futile attempt to pay for healthcare for her husband, who ultimately died of cancer. In total, she had spent something along the lines of $60,000 paying for chemotherapy, hospital stays, and various other bills. She ended up losing her job, husband, and home, all within the span of 3 months. She didn't even bother showing up for hearings or responding to the complaint, meaning my client won a default judgment against her. The worst part? I had to stand up and tell the judge what my client was entitled to: $60,000 for principal amount, $80,000 for interest and late fees, $10,000 in attorney's fees. She now has a judgment of $150,000 against her. I refuse to do that line of work anymore and have made it a point to represent people against credit cards if the opportunity presents itself. Story 9. I'm a court-appointed attorney for qualifying individuals in family matters. Termination of parental rights case. I have been advocating that the parent is stable, working lawfully, has a suitable apartment, doesn't need psychotropic medications anymore, and is ready to be a parent. After a few months of negotiating with all the parties and the Department of Children's Court Services, we had a pre-trial to try and convince the guardians. I met with my client before the hearing to see if anything had changed. Nope, all good, let's get my kids. Great, that's not happening today, but let's try. We get going in court. My client, who is very temperamental and easily angered, gets riled up and goes off on the guardians, screaming in open court. It doesn't end there, but she reveals: 1. That she is no longer working. 2. No longer in her apartment. 3. Doesn't want to have a relationship with the guardians despite her kids loving them. 4. Won't send her kids pictures of the toys they miss and can't have. 5. Plans on moving out of state. 6. Thinks they can live as a family off of state aid when she gets them back, and is 4 months pregnant. All in the matter of 15 seconds, I was too shocked to even react. Speechless. Not the image of stability and parental fitness I had been trying to demonstrate since last July. Edit to clarify. The client was working really hard to get everything right and legitimately had everything going for her prior to this hearing. I was not making false representations or trying to get a parent reinstated unjustly. This was a true shocking revelation, as I did my due diligence to make sure everything was correct and statutory requirements were met. Things move very fast, apparently. This was a very atypical situation. Parents typically work hard to meet their requirements successfully. Story 10. I primarily represent plaintiffs in personal injuries cases, and ooh boy, I have a few. The most memorable was probably during the hearing in this road traffic accident case. Based on all the evidence up to that point, it had seemed like a pretty clear-cut case of my client being cut off by the defendant when he decided to exit the motorway at the last minute. The defendant takes the stand and says that in the aftermath of the accident, my client's friend, who had been her passenger, said to him that she, i.e. my client, was not looking. This friend, who is Polish but has lived here for 10 years, is then giving evidence, and it's put to him that he made this statement. He responds in English that, "I don't speak English, so I couldn't have said that." Our barrister just looked at me horrified. I also recently had an employment law gender discrimination case where the whole thing essentially revolved around whether they had told her that her position was being terminated as a result of genuine redundancy, legal, versus whether they terminated it after she got pregnant, obviously illegal. This distinction was emphasized to the client many times, and she strongly maintained that they fired her right after she applied for maternity leave, without giving a reason. We're having a meeting with the client the evening before the hearing, and going through what the defendant will say, etc. We tell her they'll be claiming they were redundancy, and how is she going to respond? She replies with absolutely no hesitation, "Oh yeah, of course, that's exactly what they said." And then there's generally a shocking amount of people who genuinely completely forget what day an accident from which they supposedly sustained drastic injuries from happened on. Edit, because people are rightfully pointing out that some people are just bad with dates. I don't mean not remembering the specific date. I mean like coming to our office about a very recent accident, but not being able to say whether it happened last weekend or the weekend before. If it's apparently significant enough to sue over, it can't be that forgettable. Story 11. The worst case I have ever had was tangential to a family law case. I represented a non-party employer. Plaintiff's lawyers were absolutely certain he was hiding some golden parachute or similar asset. Anyway, they subpoenaed my client but sent a subpoena from their state to my client's state. My client had no business in their state, so there was no jurisdiction. We filed a motion to quash. I cannot even begin to describe the nightmare of dealing with these people. The lack of courtesy, the failure to understand basic law, no jurisdiction, failure to follow the Uniform Deposition and Discovery Act, or failure to follow state law to properly issue a subpoena. They made unbelievably broad requests. Our motion was granted, and then they filed an order for signature claiming otherwise. They served it intentionally to a different office than the one I practiced in during the pandemic, hoping I would miss the window to object. They filed a pleading in which they referred to me as an unprofessional person and routinely sent emails straight to the judge's clerk. The parties' counsel constantly sniped at each other in these emails. I filed a motion for sanctions, which was granted. The only issue left was my fees, and a hearing was set for that. In one of the many missives to the court's clerk, they sent an email which I assumed they thought was internal, but wasn't, stating they'd better settle with me, otherwise the judge was going to take action against them. A routine subpoena went awry. I know not all family lawyers are this way, but I hope to never be even remotely close to that forum again. Story 12. Special education case. Mother and school were fighting about services. We got new assessments that backed up the mother's claims. The local school didn't have the right services, so we arranged a transfer to a larger school not too far away. Good public transit route, some extracurriculars the kid was excited about. She goes to enroll him in school and says they have a problem with paperwork. Thinking the transfer info just didn't get there yet, I took a copy and headed down there. No, they wouldn't enroll him because not his legal name. She was not his legal mom. It turns out she was the best friend of a mother who was pregnant and about to be incarcerated for legal troubles. The best friend said, "Can you take my baby while I'm in jail? I'll get him as soon as I'm out." She and her husband said sure. They signed a piece of notebook paper. 12 years later. You have to think, how did they manage to navigate school and medical stuff for 12 years with no legal custody paperwork? They had just been using an assumed last name of the pseudo-adoptive couple, and, like me, no one had asked. It was only that the school had moved to an online system that checked SS-S against other databases that it was caught. Anyway, the biological mom and dad were still alive and still in a lot of trouble. They consented to the couple that raised him adopting him. The kid missed a week of school while I convinced them that he fit under a homeless youth school stability statute. Edit. Yes, it was the couple that had raised him for those 12 years who adopted him. Story 13. I filed a bankruptcy for a person. A few weeks later, they indicated that a creditor continued to contact them and had taken money out of their bank account, which is obviously a big no-no for people in bankruptcy. It was Monday. I knew that if I wanted to file for sanctions, I had to file the motion by Friday, so I wasn't going to jump right into it. It's best practice to try to get a creditor to correct their behavior first. I called the original payday loan store. I called the national branch. They took messages daily. Nobody was contacting me back. I asked for supervisors. Nobody was willing to talk about the situation, and I became increasingly frustrated. I'm not a yeller, and I'm not particularly forceful, but even I was reaching my limit. I called my client daily to explain that it made no sense that they were being evasive, but I was working as hard as I could. On Friday, I talked to some lower-level grunt and explained that I needed a call back in an hour from a person who can clarify the situation, or the sanctions motion is being filed. I read off my time spent on the case, which would translate into thousands of dollars in sanctions if we were successful. I finally get a manager. He, very politely, tells me that the client took out the loan after the bankruptcy was filed. I remember deflating like a popped balloon. My client had taken out a relatively big payday loan a week after the bankruptcy. They confessed that they knew it wasn't included in the bankruptcy, but thought the lender would go away if an attorney got involved. That's probably mild compared to the things that I see in bankruptcy, but most I probably shouldn't disclose. One of the major tenets of bankruptcy is that a debtor has to make a full and honest disclosure of their income, expenses, assets, and debts. So naturally, there are tons of reported cases of people hiding things to try to get out of their debts without surrendering assets. Story 14. Got a DUI client who had postponed his trial date by almost 2 years. He had a history of DUI but had cleaned up his act until this one. His story. He was sitting in his car waiting for a ride when he got picked up, no keys in the ignition, and he talked to the cops by opening the door. There was no way he could have driven. The cops. Story. Keys were in the ignition, and the window was down. No one disputed that he was very drunk. His case was winnable, but for one problem. He couldn't keep his mouth shut on the stand. If I asked him the time, he told me where his watch was made and the name of the clerk who sold it to him. Classic someone who talks too much. His friends were his other witnesses, and I couldn't have asked for better ones. The police were the prosecutor's witnesses, and I poked holes in their testimony left and right. The case was far from an airtight acquittal, but I had more than enough reasonable doubt to win, except for my client. He revealed on the stand that it was his 4th DUI, when, as far as anyone on the jury knew, it was his first. Then he couldn't keep his story straight about how he talked to the cop. Opening the window versus cracking the door, which matters because the key would have had to be in the ignition for the windows to roll down. If I tried to rein him in, he went off on another tangent. And this was all after refusing to plead to a stipulated first offense, which would have meant fines and traffic school. Instead, he undermined his own case, got convicted, received something like 60 days in jail and a large amount of costs, and I got frustratingly close to a win. Story 15. Nasty custody fight. The ex-wife was a lawyer and represented herself. The ex-husband had a pretty ineffective lawyer. She kept bringing issues back to court to try to get more benefits from him, and his lawyer just let it keep happening, which was treating him unfairly and affecting his life. Allegations of child abuse, financial strain making it difficult to afford an apartment or a car, both of which later factored into custody. Finally, the ex-wife's father, also a lawyer, asked to meet with the judge and mentioned a few things he knew were going on. One of the children was manic depressive, and the ex-wife would take him off his medication before it was the ex-husband's turn for custody. The child abuse allegations arose from the ex-husband trying to manage the child during a manic episode because he wasn't medicated. The ex-wife had intentionally timed the child abuse allegation to fall just before the holidays, so the ex-husband couldn't see the kids for Halloween, Thanksgiving, and Christmas. She bragged to family that it would cause maximum emotional distress. The ex-wife had forged documents to overstate the ex-husband's income when alimony was being determined. The ex-wife had an inappropriate relationship with the ex-husband's lawyer. Story 16. Too many criminal client situations to count of them undermining their own cases. One of the very few family law cases I handled as a young attorney sticks out. A young woman and young man had a child. The young woman sought a divorce because he was involved in a risky lifestyle. He had recently been arrested and charged for possession of illegal substances with intent to distribute, felony, and illegal possession of a firearm. The young man didn't want her to leave. He hired a well-known local divorce attorney in a fairly rural area and obtained a temporary order prohibiting her from having overnight guests of the opposite sex. The young woman started seeing someone new. Upset, the young man had his attorney request a hearing, accusing her of violating the court order and seeking full custody, plus attorney fees. Following advice from a mutual friend, she hired me for the hearing. At the hearing, I brought a copy of his probation arrangement for the previous charges, which opposing counsel was unaware of. She questioned him about my client having a new boyfriend over. The judge, being very conservative, was displeased. Opposing counsel then attempted to question the young man about income. Do you have a job? No. What do you do for money? Things here and there. Have you ever engaged in illegal activity to make ends meet? No. I then introduced a copy of his guilty plea and probation sentencing. The judge was visibly displeased. I leaned over to my client and quietly asked, if you took a drug test today, would you be completely clean? She confirmed she would. Edit. Outcome. The ex-husband's lawyer was reported to the bar, not sure of the result. The judge ordered a review of everything and arranged for a new lawyer for the ex-husband. It looked like alimony would be significantly reduced, and the ex-husband was going to get custody. Unfortunately, the ex-husband died, blood clot, 2 months later. After years of being treated unfairly, he finally saw a light at the end of the tunnel, but it turned out to be the wrong light. Story 17. One of my clients really surprised me. I was a public defender, and a pro se defendant didn't want a lawyer, but the judge appointed me anyway. I met with him outside the courtroom. He started accusing me of being, quote, part of the big machine trying to railroad him. I said, look, it's my job to advocate for you. If you don't want a lawyer, that's your right. I'm going to go back into the courtroom and argue very strongly to be removed from your case so you can represent yourself. He was stunned and said, you must be one of the good ones. I'll let you represent me. This decision was the beginning, middle, and end of his common sense. He was facing serious criminal charges involving coercion and theft. His landlord had refused to fix a TV in a furnished rental, so he hid outside the landlord's house and coerced him with a weapon to go inside and withdraw cash from an ATM. His defense, I have it in writing that he owed me that money, I explained. Even if he owed you money, you're not allowed to do that. That's literally why small claims court exists. If these allegations can be proved, you're likely to be convicted. Ultimately, he decided to represent himself on the day of trial. He thanked me for my help, then said, the only way I'm going to beat this is if I do it myself. The judge gave him the mandatory minimum, 10 years, but was relatively lenient considering the circumstances. Story 18. I had a client charged with shooting and paralyzing the victim. He was identified by a woman in the house who knew him, but the witness was potentially biased. The client said he wanted to fight the case. We then discussed whether the trial should proceed time waived or time not waived. Time not waived means the trial is set within 60 days. Time waived means it can start later. My client insisted he was not at the scene. I stressed the importance of being honest and that everything is confidential. I suggested we could obtain cell phone records to confirm his phone's location. If the records showed he was using his phone elsewhere, it could support his alibi. If he were at the scene, setting the case as time not waived would prevent the DA from accessing the records early. The client chose to set it time waived and get the records. Several months later, the cell phone records literally showed him at the crime scene at the time of the shooting. They also implicated his friend and provided more evidence linking him to the incident. I shared the details with the client. He had no reaction and gave no explanation for his prior statement. I advised accepting a plea deal before the DA discovered this information, warning that the offer would increase if they did. The client insisted on a jury trial. I explained that it was his choice, but it was risky. As the jury entered the courtroom, he suddenly asked to accept the deal. Because of his delay and decisions, the offer increased by roughly 300%. Had he taken the original offer, he would have been released sooner. Now he faces a lengthy sentence. Story 19. I had a client who was in and out of prison and had clear mental illness and aggression issues. He was very threatening, rude, and psychotic. Details omitted. During his trial, he appeared by telephone. When opposing counsel began their opening statement, my client started shouting that the lawyer was lying and spouting complete nonsense. I told him to let the attorney finish and that we would respond later. He insisted he had to correct the lies himself, but I explained the procedure, and he calmed down. Throughout the trial, he made snarky and angry remarks under his breath and occasionally yelled at the other lawyer. The judge intervened multiple times, warning that if I could not control my client, he might lose the right to speak for the remainder of the trial. I had to calm him repeatedly with phrases like, "Mr. X, don't worry, we'll have our turn." The trial, which should have taken an hour, lasted 2.5 hours. At the end, my client began to address me with a potential threat, but I immediately stopped him. Based on prior conversations, he may have intended to threaten someone, but I cannot be certain. The trial was lost. Weeks later, I heard that people from other rooms could hear my client shouting. P.S. With many exceptions, lawyers are underpaid for the complex situations we handle. We act as researchers, editors, therapists, counselors, middlemen, advocates, and officers of the court, all in one. We deal with a lot of societal drama and receive criticism, but much of it comes from managing difficult circumstances. Story 20. I represented a man on his second marriage. His first wife had passed away from cancer, and he and his children were understandably devastated. My client was a sensitive man with a big heart. His second wife could be very charming. This was why he had fallen for her, but it was largely a facade. During the divorce proceedings, my client met a kind and affectionate woman, and they became engaged, even though his divorce was far from finalized. Later, the fiancé was diagnosed with a form of terminal cancer. Somehow, the second wife found out and attempted to use the diagnosis against my client in court. She developed an unfounded theory that my client had caused his first wife's cancer, and was attempting the same with his fiancée. The second wife's attorney refused to participate in this argument and did not address it during testimony. Instead, he informed the judge that the second wife wished to speak directly. The judge allowed it in a highly irregular move. She presented her unfounded theory, claiming she believed my client was responsible for the fiancé's illness as well. I wish I had an artist's rendering capturing the second wife's intense expression, her attorney's look of embarrassment, the judge's confusion, and my awe-inspired reaction. Story 21. My brother is a divorce attorney. His most memorable case: he was representing a guy in a divorce custody battle who was accused of horrific child abuse. Very graphic, very detailed depositions from the young kids against daddy. Things look grim. Then my brother, a failed actor, notices the deposition transcript, done by social workers under oath, contains a question at the end from one of the kids: "Did I hit my marks?" He wonders how little kids know about acting jargon. Subpoenas wife's personal checking ACCT during discovery. Sure enough, acting lessons. Deposes an extremely sketchy acting coach, and panicked coach produces DVDs of practice interrogations with the kids, hours of coaching the kids on exactly what imaginary things to say about daddy. He says it was his one and only Perry Mason moment in 20+ years of practice, and dad got sole custody of the kids. Story 22. One of my all-time favorites is the marriage of Thomas and Denise Rossi. I am not connected to the case, but it was a notorious case that resulted in a published California Court of Appeal opinion, which means that all the details are public record. Denise Rossi won $1.3 million as part of a group of co-workers who joined a lottery pool together. 11 days later, she filed for divorce and moved out. She never mentioned the winning lottery ticket to Thomas. She also did not disclose the proceeds as either her separate property or as community property during the divorce. And she would have gotten away with it too, if it hadn't been for the letter that was sent to the marital residence over 2 years after the divorce had been finalized. The letter was an offer to buy out Denise's lottery annuity with a lump sum payment. Thomas promptly lawyered up, and the family court awarded 100% of the prize proceeds to Thomas. For the legally curious, please understand that California is a community property state, which means, among other things, that all earnings during marriage are community property that is owned equally by both spouses. Anything obtained using community property funds, like a lottery ticket, is also community property. There are also heavy penalties for violating the disclosure requirements that come along with a divorce in California family law matters. You must disclose all of your assets to the other side, even if there is no question that some of the assets are your separate property. In any case, where a party to a divorce fraudulently conceals a community property asset, as with the Rossis, it is mandatory under Family Code Section 1100 for the court to award 100% of the asset to the other party, and other penalties can also be applied. For the legally nerdy, the case citation is 90 Cal App 434.